Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you on the behalf of the Indraprasth Law College, Greater Noida. In today's lecture, we are going to discuss about the sources of international law. So now let's open the books and start the slide. Yeah, sources of international law. If we talk about the sources of international law, means that the स्रोत जहाँ से कोई भी सब्जेक्ट मान लीजिए इंटरनेशनल लॉ है, सोर्सेज मीन्स कि कहाँ से इसका ओरिजिन हुआ है, व्हाट इज द बेसिकली original concepts which is covered into the sources of international law. As you already know that since time immemorial, states and peoples have entered in formal relations with each other. Over the ages, traditions have developed on how such relationships are conducted. These are traditions that make up modern international law. And like domestic law, international law covers a wide range of subjects such as security, diplomatic relations, trade, culture, and human rights. But it differs from the domestic legal system in a number of important ways, as we have already discussed in the previous lecture in the municipal laws, in the name of municipal laws. And that's why we are now discuss about the sources of international law. What is the basic concept behind it? And that says that international law is comprehensive in nature, and due to that it is an amalgamation of the various sources. There exists no single system of laws which can interpret and extend the law, but international law still exists and is ascertainable. As you already know that nature of the international law, while many jurists are not accepted it as a true law, but somewhere it is existed at that modern era. That's why the sources of international law is important to know about that, and that is a very essential part which is covered into your exam papers into the 20 marks. Let's start with the next slide. The next important point is that the classification of international law, classification of the sources of international law basically. That means according to Lawrence, before the Lawrence we will discuss about the classification of sources. What is the classification of sources? In international law there is no single legislature, nor is there a single enforcing institution, as we already know that. Consequently, international law can only be established with the consent of states and is primarily dependent on self-enforcement by those same states. In cases of non-compliance, there is no supranational institution. Enforcement can only take place by means of individual or collective actions of other states. That's why this consent from which the rules of international law are derived may be expressed in various ways. The obvious mode is an explicit treaty, as you already know that about the treaties, imposing obligations on the state practices, sometimes state obligatory having a part of the international law, and then such treaty law constitutes a dominant part of modern international law. That's why according to Lawrence says that if we take the source of law which has all the authority required to give it binding force, then in respect of international law there is one source of law, that is the consent of nations. Means that consent of nation is an important part of international law. If a state has not consented with the international law, then there is no international law which is developed into that nation. That's why this is most important part of the international law, or the classification or the sources, classification of the sources of international law. That's why this consent may be two types, either tacit or the express. कई बार ये tacit भी हो सकती है. Tacit means customary, कस्टमरी नियम बन जाते हैं, कस्टमरी लॉज दो देशों के बीच डेवलप हो जाते हैं, और कई बार ये एक्सप्रेस कंडीशन में ट्रीटीज के तौर पर देखने में आती है। ट्रीटीज मीन्स दैट इज अ कॉन्ट्रैक्ट बिटवीन द टू नेशंस। एंड लेट्स मूव ऑन द नेक्स्ट स्लाइड। Although Oppenheim defines the term source of law as the name for a historic fact out of which rules of conduct come into existence, the term source refers to methods or processes by which international law is created. And that's why some jurists says that the classification of sources is divided into two parts. First one is primary sources and the second one is secondary sources, and Oppenheim already converted this part into the formal sources or material sources. Formal source means the legal procedure and methods for the creation of general rules, and material sources means the actual materials providing evidence of the existing rules. Let's move on the next slide. Primary sources. Now we will discuss about the primary sources. What is primary sources? The source of international law are many, and states commit to them to different degrees, and the internationally accepted classification of sources of international law is formulated in Article 38 of the Statute of ICJ, means that International Court of Justice. Article 38 1 subclause A to subclause C is the most important part, which covers the primary sources of the international law and defines what is the primary sources of international law. But basically the primary sources of international law are considered formal in nature, wherein the Oppenheim says that the formal sources says it as a formal sources. That's why primary sources is covered into the Article 38 of the ICJ statute. So let's move on the next slide. That is Article 38 of Statute of International Court of Justice, means that ICJ. Article 38 1A to C, subclause A to C, previously called that it was adopted by some provision of the statute of the Permanent Court of International Justice, which operated under the auspicious support of the League of Nations in 1920. League of Nations is also a part of the UNO. Before UNO, that is the authority which is being created by the various nations for the harmony or the brotherhood among the nations. But anyhow it fails, but we have to know about the historical background wherein the Article 38 of Statute of ICJ has been established, and the Article 38 of the Statute of ICJ covers as the primary sources of international law and defines it in the name of that four major sources. The first one is international convention, the second one is international custom, the third one is general principle of law, and the fourth one is judicial decisions. So there is a four primary sources which is described in Article 38 of the Statute of ICJ. So remember it is most important part. We will discuss later on about all the primary sources in details. Now we will discuss about the next slide. Yeah, that is the secondary source. Historically, the writers on the international law such as Gentile, Grotius, Pufendorf and Vettel were a primary factor in the evolution of the modern international law. They were the supreme legal authorities. They were the supreme legal authorities of the 16th to 18th century. We have already discussed in the previous lecture, wherein we have discussed the historical evolution of international law. If you have seen that video, you covered that part. But basically, they determined the scope, form, and content of international law. However, the importance of legal writings began to decline as a result of the emphasis on the state sovereignty. Treaties and customs assumed the dominant position in the exposition and development of international law. That's why the secondary sources is also essential part of the international law. Wherein article para 2 of the article 38 of ICJ covers two types of secondary sources of international law, which is basically writings of legal scholars and ex aqua et bono, that is a legal term, means that equity. So we will discuss later on about the both parts, what is the equity and what is the ex aqua et bono, and the writings of legal scholars. Already known that many jurists has come and give their definitions in the various forms, just like Oppenheim says that that is a formal or material sources, and the other one says that that is the primary and the secondary sources. But there is a different opinion, and concludes the various concepts into a form of law that is called as a international law, and previously known as a law of nations, described by the Hugo Grotius or the Jeremy Bentham. So I think you will have been enjoyed the whole session, successfully enumerated into your study, and be benefited from this presentation. Thank you. We will meet soon with a new session. Thank you very much.